huge understanding of our work in the Committee on the Peaceful Use of Outer Space and the Legal Subcommittee in particular, but also has a wide range of experience in the security side of things. And without taking any more time from our Ambassador Lagos, I'd like to just go ahead and pass the floor for you to share a few words on your experience in lately in the disarmament field and talking about, of course, Article 4 of the Outer Space Treaty on prohibition of placement of weapons of mass destruction and nuclear weapons in outer space. Ambassador Lagos, please, the floor is yours.
Good morning, Michael, and good morning to everyone. Can you hear and see me?
Yes, we can, sir. Thank you.
Okay, that is great. Well, first of all, I would like to apologize for my voice. I am on sick leave, but nothing dramatic, so it should be okay by tomorrow. But my voice is not perfect. It's even deeper than it usually is. So I would like to thank you, UNOOSA, for the invitation to participate in this very relevant and timely United Nations Conference on Space Law and Policy, the Outer Space Treaty for the 21st Century. Specifically, I have been requested to speak on Article 4, and in particular on behavioral norms in outer space activities and the future of space security at a multilateral level. So in this regard, I would like to say that from a historical perspective, it is worth remembering that the main coding human activities in outer space were already expressed at the beginning of the space age, with the adoption in the General Assembly of the Declaration of Legal Principles governing the activities of states in the exploration and use of space, as Mike just mentioned. This declaration later served as the basis for the negotiation of the Outer Space Treaty in 1967. Now, this treaty stipulates that the exploration and use of outer space shall be carried out for the benefit and in the interest of all nations, and that it shall be the province of mankind. I prefer to say humankind, but that was the wording of the 1960s. So regarding Article 4, as we all know, it states that the parties undertake not to place objects carrying nuclear weapons or other weapons of mass destruction into orbit, and the installation of military bases, the conduct of military exercises and weapon tests on celestial bodies are prohibited. So how does that apply in the current situation? How that has the application of that article evolved in the last decades? First of all, regarding the current situation, it must be recognized that the situation has changed dramatically since the treaty came into force in the late 1960s. As a result of the current trends, we can identify various consequences. The increasing competition among space actors, a concern about an eventual disruption of basic services derived from space technologies, a growing distrust and concern about possible threats from military technologies, including the possible installation of weapons in space, the use of ground-based weapons that could destroy satellites, intentional interference, also known as jamming, the congestion of space orbits, the creation of debris. And some countries have expressed concern about the military nature of space activities in general that could violate the principle of exclusively peaceful uses. Now, regarding multilateral initiatives, the international community has attempted to address these concerns through diverse initiatives. Some of these initiatives have been, for example, the process of the group of governmental experts on transparency and confidence building measures in space activities. Also, I would like to mention the European Union's proposal for an international code of conduct and the group of governmental experts on the prevention of an arms race in outer space, PAROS, which had already, there was one of these GGEs on PAROS that happened a few years ago, which I had the honor of joining, and currently there is a new one going on in Geneva, a new attempt. Despite partial progress in these processes that I have mentioned, important differences have remained between the main space powers, in particular regarding the challenges to space security. Now, I would like to elaborate a little bit about the recent process of the open-ended working group that I had the honor to chair. And regarding this, I would like to say that this new approach is based on the responsible behaviors of states, which seeks to agree on norms, rules, and principles on behavior in order to achieve a greater trust between actors and strengthen space security. And in this regard, it is worth remembering Resolution 76231, through which the General Assembly decided to convene, starting at the beginning of last year, 2022, a working group, which was called the Open-Ended Working Group on reducing space threats through norms, rules, and principles of responsible behavior. Now, the mandate of this group was to take stock of existing legal and other international frameworks relating to threats arising from the behavior of states with respect to outer space, then to examine current and future threats by states to space systems and actions, activities and omissions that could be considered irresponsible, and to make recommendations on possible norms, rules, and principles of responsible behaviors in relation to state threats to space systems, including, if applicable, how they would contribute to the negotiation of legally binding instruments, including on the prevention of an arms race in outer space. And finally, to submit a report to the General Assembly at its 78th session. Now, regarding the process and how it went, I would like to make a summary, a very short summary, because I know we have limited time. Following this mandate, the group subsequently considered all the elements of the mandate. In the first sessions, therefore, the legal situation and the threats were considered, while in the third session, the group considered the third element, which consists of making recommendations on possible norms, rules, and principles of responsible behaviors in relation to threats from states to space systems. Now, in this context, states emphasized the applicability of international law to the space domain, and in particular, Article 2.4 of the United Nations Charter, which, as we all know, prohibits the use or threat of use of force. States also highlighted the importance of UN space treaties, with several delegations indicating that there was a need to clarify the interpretation of certain principles that are enshrined in the agreements, such as the principle of due regard established in Article 9 of the Outer Space Treaty. Several states also highlighted the complementarity that exists between legally binding mechanisms and non-binding instruments, and noted the role that the latter can play in facilitating clear interpretation of existing laws. Furthermore, several delegations indicated that non-legally binding norms, rules, and principles could eventually help to create the basis of common understanding that is necessary to build an effective legally binding agreement on space security. States also discussed the need to improve information sharing on space security doctrines and policies, as well as activities that could be perceived as threatening, such as rendezvous and proximity operations. They also exchanged views on the possible uses of space situational awareness and space traffic management as tools for monitoring and verifying compliance with legal and regulatory frameworks. The discussions were, I would say, and most of the participants, I think, would agree, were largely fruitful, constructive, and interactive, resulting in an exchange of positive views, although I also have to say important differences were confirmed, such as the need to discuss the applicability of international humanitarian law to outer space, and also the relevance of the responsible behavior approach. Now, regarding the fourth session, I have to say that the first three sessions really achieved to fulfill the purpose of initiating discussions and engaging delegations in a debate that I have to admit is not only controversial, but sometimes also highly technical. And in this regard, the contributions made by the experts in the morning panels, in particular of the first two sessions, have been very useful in helping guide the discussions among the members of the OEWG. However, important differences, as I said, have still been noted between some delegations, in particular regarding perceptions of threats and what the nature of measures should be to mitigate such threats. While some delegations believe that these discussions should necessarily lead to the negotiation of legally binding international instruments. Others are convinced that non-binding voluntary commitments can actually constitute a pragmatic alternative that can help address current and future threats. However, dialogue in the OEWG has demonstrated an emerging shared understanding that these two options are not mutually exclusive, as set out in the group's mandate itself, which urged the OEWG to consider how legally non-binding mechanisms, such as norms, rules, and principles, can contribute to the negotiation of legally binding instruments. Furthermore, the new approach underlying the mandate, which, as I mentioned, is focused on behavior rather than capabilities, has actually facilitated a more innovative debate without replicating the traditional and very well-known arguments to us all of established international fora, such as the Conference on Disarmament. However, the adverse international geopolitical situation has been present since the beginning of the work of the group and has represented an additional obstacle to achieve consensus on an issue of high political and technical complexity. Despite of this, many delegations have supported the OEWG approach as a basis for pursuing initiatives that are perceived as potential ways to address some of the main threats to the security of space activities. Now, regarding the draft report, in my capacity as chair, based on the discussions and the working documents presented by delegations, I prepared, with the very competent help, of course, of the Secretariat, a document with the main elements of proposals presented for the final report. Subsequently, after receiving the corresponding reactions, we prepared the zero draft under my responsibility, which was circulated among the delegations as the basis for the discussions and negotiations of the fourth session. This document includes the main threats that have been identified in the discussions and the recommendations to address the threats. Now, in the discussions, the delegations reiterated their positions already expressed in previous sessions of the group. And in this regard, I would just like to mention some of the main topics that were discussed. Now, regarding international law, delegations generally agree on the applicability of the Outer Space Treaty and other sources of international law, in particular the Charter of the United Nations. But however, some states are reluctant to include any reference to international humanitarian law, which applies in times of armed conflict. Even so, many states refer to the importance of its applicability, as well as the relevance and contribution of the International Committee of the Red Cross on this issue. This concept definitely continues to divide the delegations and has been one of the obstacles to reach a consensus report. Now, regarding the responsible behavior, although many delegations have recognized the added value of the responsible behavior approach, some states continue to object to this concept, which, as I said, underlies the mandate of this group. They argued that it is subjective and confusing, and some even said that it is actually of political nature. Now, there was a lot of discussion also regarding the destructive anti-satellite testing, ASATs. There has been a significant debate in the OEWG about these tests, including a growing international moratorium on direct ascent anti-satellite tests. Some of the resistance to this initiative is not only against the restriction and moratorium, but for some delegations, this commitment does not go far enough. Now, regarding the scope of the report, delegations that do not support the objective of this group, and particularly the focus on norms of responsible state behavior, claim that their views are not adequately reflected in the draft report that we have prepared. Some states have also protested that the report does not take on board all of the issues raised during the discussions. On the other side, we have other delegations that considered that the draft report was too comprehensive. So it is always a challenge to try to balance these expectations. Now, regarding rendezvous and proximity operations, A diverse group of delegations mentioned the need for rules on these operations, known as RPOs. The other issue that is always present in these discussions is space weapons. And one of the fundamental elements that have been promoted by those delegations that have presented a proposal of a treaty to prevent the placement of weapons in outer space, particularly the Russian Federation and China, is the recommendation not to develop, deploy, or test weapons in space. And in this regard, promoters of the responsible approach have reminded that the focus of this group in particular is on behavior and not capabilities, and that the use of force is already covered by the United Nations Charter. Now, there is also some new elements of discussion that have actually enriched our debate. In addition of recognition of IHL and international human rights law, one delegation in particular, and I think they don't mind that I mention them, Canada, called for recognition of the need for gender inclusive perspectives and recommendations. I have to say that this initiative has received a very significant support by delegations. Now, given the exhaustion of the debate and the impossibility of agreeing on a final report, I invited the delegations to make their final interventions in the last day of our session. It was evident that the new approach underlying this process has actually contributed to provoke an intense and generally constructive discussion with a broad participation of delegations from all geographical regions and different levels of development in the spatial field. Likewise, interregional alliances have been established, which have modified the traditional blocks of multilateral diplomacy, particularly in the realm of international security and disarmament. One of these examples of this interregional collaboration has been the collaborative work of the Philippines and Germany on the issue of the obligation of states to take due regard in space activities, one of the principles enshrined in the Outer Space Treaty. Also noteworthy is the emerging common understanding on some core issues, including the full applicability of international law, including relevant rules of international humanitarian law, where relevant, the importance of promoting greater transparency, greater trust, the need to address threats that are represented by the destruction activities of space objects that generate space debris, proximity operations that can cause misunderstandings and miscalculations, and also the importance of achieving a better protection of critical services for the civilian population, among other aspects. Another very valuable aspect that should be highlighted is the active participation of civil society delegations, especially in the first sessions, in which we have benefited from the knowledge of various experts from academia and the space industry. In this sense, it is worth highlighting the fundamental contribution made by the ICRC. I mention it again because that participation has been really decisive in achieving a better understanding of the applicability of the norms of international humanitarian law in outer space. The discussions in this process have reflected a growing awareness of all delegations about the priority need to jointly address these global challenges, despite of the additional obstacles related to the current geopolitical situation. It has also become evident that there is an emerging shared conviction about the positive contribution that non-binding rules and political commitments can make to strengthening space security and in supporting efforts to achieve legally binding instruments. All of these initiatives can actually contribute to progress towards the common ultimate goal of preventing an arms race in outer space. So, Mike, I know you are worried. I am wrapping up now. So what is next? Currently, the new GGE on Paros, which was established by United Nations General Assembly Resolution 77-50, is holding its first session in Geneva with the mandate of considering and to make recommendations on some substantial elements of an international legally binding instrument on Paros and the prevention of an arms race in outer space. It is a second attempt, as I mentioned already, as the first GGE on Paros was not able to achieve a consensus outcome. Considering the current geopolitical context, the situation is not ideal for this process, but I sincerely hope that it will be able to find this agreement. The international community urgently needs some good news, particularly on this very critical issue. So I really wish that group, which is chaired by my dear friend Bassem from Egypt, has more success than I had chairing my group. Thank you very much, and I'm open for questions. And sorry if I was a bit long.
No, it's really our pleasure to hear your comprehensive review of this work, this very, very important work that you've been doing and the international community has been doing. And just, you mentioned so many things that we have in common. I mean, and this is what has been recognized throughout our committee, and also I know in Geneva, and that disarmament context has been recognized as well. You know, this notion of due regard. We will hear shortly in our presentations today from Professor Marchisio on aspects of due regard and how that fits into this into our. He's also former chair of the legal subcommittee as well. So we have great background on all of this. And one thing that I would like to raise before I go to a question here that I see in the chat is, what are your thoughts on the use of space situational awareness and the contribution that states can make to a understandable playing field of what exactly is happening out there, and that could contribute potentially to the way in which states behave responsibly. Do you think that there is an opportunity for greater information sharing, or is there an opportunity to maybe make a platform that we can have better space situational awareness, potentially the burgeoning of space traffic management that could also contribute to responsible behaviors? What are your thoughts on that as even a way of moving into these non-binding ways that we can cooperate versus and then maybe even moving into a binding situation? What are your thoughts on that? Thank you so much.
Thank you very much for your very relevant question. Actually, this is one of the points that has been discussed quite thoroughly, and most delegations have realized that this is really a critical point. It is very important to strengthen and the sharing of information in this regard, and there is a growing awareness of delegations, particularly by new players. Because the interesting thing that we have realized in these discussions, and particularly for those of us that have been involved for some years, is that there is a growing understanding of delegations. As I like to say, the days are over when there were only a few space actors. We used to make these categories about spacefaring and others, and actually we can now say that all delegations, all countries are actually actors. There is no country on earth that can say, can afford the luxury of saying, I am not involved, this doesn't apply to us. So these things are really important in order to avoid situations that can be really critical, particularly for services that are so important for the civil population of states. So in this regard, I must mention that there are a few initiatives to establish platforms. Some have already been established in this regard with the help of different organizations, including the UN. And this is something that has been very much appreciated, and it shows how this responsible behavior can actually be very concrete. And it doesn't mean that immediately this approach will lead to a major new treaty that will solve all problems. But with the current existing legal regime, in that framework, we can do much more. And these are practical steps that are really necessary for states. And I see it as in a germinal state, because this interaction and this process of sharing information and really being able to access this information is beginning to evolve, and it's going to be a very big issue for the next couple of years. I'll stop there. I think you're muted, Michael. Mike, you're muted.
Oh, I'm so sorry. Thank you so much. Please stay with us just for a second, and I would like to call on our colleagues in Roscosmos. Vasily, I believe that is you. You said you wanted to make some comments. That would be excellent to hear from you. Thank you so much. You were on mute as well, sir.
And now?
Yeah, we hear you now. Thank you.
Thank you, Mike, and thank you, Ambassador Lagas, for very comprehensive report on what is happening in Geneva. And I would like to comment some points of your report. Overall, over using of force, how we understand this sentence. For example, if I'm trying to help an old woman to cross the road, despite she is not intent to do that, is it using of force or not? So in our point of view, use of force could be in different forms. For example, any action taken without permission or previous permission of launching states against an object or communication lines, data lines, and control lines, despite the purposes the intender would like to pronounce to help us or to facilitate or to resolve some situation, is using of force. Because then someone would like to help, for example, the first step is obtain the permission of the launching state. Because in accordance with the provision of international treaty, it could be considered as a violation of property of the launching state. That's the first statement. And due to principles, rules, and norms on responsible behavior. In our point of view, responsibility and responsible behavior are quite different. Responsible behavior could be considered as a moral, then responsibility is a legal aspect. And this responsible behavior mostly based on historical culture and other background of the launching state. And for us, then we are talking about the responsible behavior. The main question is what is criteria to consider the behavior of the launching states as responsible or unresponsible. And as we presented during this open-ended consultation of the working group, we said that for us, there is only one criteria to consider responsible behavior because of the goal to preserve the water space for use in peaceful manner, for peaceful purposes. And any actions that take us away from this goal could be considered as irresponsible. That's all. Thank you very much.
Oh, Vasily, thank you so much for your comments. That is really very interesting as well. And I would like to note that when you speak of these aspects of rendezvous and close proximity, potentially maneuvers and things like this, that yes, there is this. Obviously, under Article 8, states retain jurisdiction over their space objects. They are launching states. You're absolutely correct. Ownership remains firmly entrenched within the state of ownership and registry, and that is the function of a state. And it would be, of course, I think it is definitely something that any country or any company potentially that would be looking for active debris removal, I mean, this is something that they must ask permission for, that this is something, and this is exactly the kind of information sharing and framework that that I think we can foster, especially in the peaceful uses context, where we can work with our existing knowledge base, our existing registry of objects launched into outer space, understand the functional and non-functional ones, and really come to grips with ways to address growing space orbital debris, especially from the non-functional ones, and to facilitate technological development of and technological demonstrations of capabilities to really clean up orbits. And I hope that that as the technology becomes more available, that states will also become more willing to share this information, and also be willing to say, okay, our ownership rights allow us to say, okay, now we deorbit, we use services, potentially we can contract for services to do this. And I hope that that addresses some of those ideas that you were having. I mean, we hope that there can be a combination of peaceful uses and peaceful activities and commercial activities that can address some of these long-standing issues of ownership and control of especially legacy space objects that are out there. And of course, we will always continue this discussion as well. It's really, I'm so glad that you came in and mentioned this, Vasily. This is excellent as well. Ambassador Lagos, yes, please.
Thank you very much. Thank you very much, Vasily, for your statements. There were, I think, not really questions, but I allow myself to make some comments, particularly on the second statement regarding the responsible behaviors approach. And in this regard, I really appreciate your intervention, because I didn't have enough time to elaborate on the diversity of views and reactions on this underlying approach. And considering that your delegation was the Russian Federation delegation, that was one of the delegations that expressed reservations on this approach, I think it is really very valuable for all of us participating in this important conference to hear from the delegation itself, because if I explain it will not be absolutely correct. But in this regard, I just would like to say that this approach is relatively new, and there was some skepticism about the possibility of using it for the discussions. And I think that most of the participants have realized that it actually helped the purpose of igniting a discussion in a way that allowed for thinking a little bit out of the box with more creativity, and getting away from the very defined positions that binary discussion that we hear usually in the Conference on Disarmament, of two different views. This allowed also, it motivated other delegations to participate very actively. So in my view, it really helped us to have a discussion that those that have served in Geneva particularly appreciated, because of the creativity and the good atmosphere of most of the discussions. But obviously, there was not a consensus, and because there was not a full understanding and sharing of this, not all delegations accept this concept, and that is something that is a fact. And because of that, we were not able to achieve consensus, as I mentioned. But for all of us that, those of us that are multilateral diplomats, we know that this is very slow, and we have a lot of practice in patience. So we are not completely frustrated, because we know that we will continue to make progress. And I certainly hope that the current GGE, that is actually based on a more traditional discussion, will be able to not only have success, but also to take some of the lessons that we have learned from our process into it, because all of these processes, the way I see it, are interrelated. And I hope that, as I said, that GGE will have more success than I did. Thank you.
Thank you again so much, Ambassador Lagos, for your sharing your views and your experience in working in this area. It really is our pleasure. Vasily, do you have any final comments that you would like to make on this topic?
I appreciate the comments made by Ambassador Lagas, and I said, yes, there were a lot of differences in the position of delegations during the discussion in the open and working group. We presented our view, and we suppose there are two different kinds of threats or problems. One part is the result of space activities like space debris, possible collisions, and so on, like emissions from the engines. But other problems are the result of political decisions, and those political decisions taken by states, certainly. That's why then we are talking about the responsibility of states or responsible behavior of states. Overall, we are talking about those political decisions, because all questions related to the exploration and use of total space in peaceful purposes is the questions of the COPIOS and its subcommittees. Thank you.
Thank you for those final words. That was excellent. Thank you again for your contribution, Vasily, and thank you for adding to the flavor of this very complex work that is happening in the security side of things, in the Geneva context, in this open-ended working group, and this long continuity of this work that has been going on, as you say, Ambassador, for a number of years, and will continue likely. And we hope that there is success there, and we really look forward to hearing more about how all of this goes, and we really hope that you get a chance to participate more in this work. I know that there's also proposals for another open-ended working group coming around again, as well as this GGE group as well that's currently meeting. And it really is eye-opening from the side of the committee side, from the peaceful uses side here in Vienna, to see this different perspective and to understand these interlinkages of our work and how we can contribute, of course, to disarmament efforts and how peaceful uses can do this as well. I noticed in the chat it was mentioned that some national efforts to bridge this gap of understanding and working out agreements between owners of satellites for especially this deorbiting and the rendezvous proximity operations is ongoing as well. And we look forward to seeing more of that and to seeing some real results come from all of these efforts, nationally and multilaterally. With that, I would like to thank you so much, Ambassador, for sharing your time. We hope your health improves and that you feel much better very soon. And thank you, Vasily. We'll be talking in just a moment. And now, without further ado, I would like to turn now to our next presenter. Thank you, Ambassador. And turn to our next presenter, Professor Yun Zhao from the University of Hong Kong, who will share some words for us on our next article as we move through our Outer Space Treaty on Article 5. And this very interesting understanding and interpretation of this article that has happened in recent years as well. Without any more introduction, thank you, Professor, for stepping in and coming into our conference. Please, you have the floor.
Thank you very much, Michael. Thank you for the invitation, and it's a great pleasure for me to speak in this very important event. And of course, I think we'll be very happy to talk about something regarding Article 5. Let me first of all share my PowerPoints.
Yes, please do so. Thank you.
Okay.
Yes, we can see it.
Okay, yeah, thank you. Okay. As I was, the topic, I think, basically is on Article 5, assistance to astronauts. So as a background, as a Starlink satellite approached the Chinese space station in 2021, I think basically twice, July 1st and October 21st, the Chinese space station implemented emergency collision avoidance on 2 occasions to ensure the safety. Later on, in the same year, on December 3rd, 2021, China notified the Secretary General of the United Nations in accordance with Article 5 of the Outer Space Treaty of the above-mentioned phenomenon, which constitutes a danger to the lives and health of astronauts. This is the first time that a country has invoked Article 5 of the Outer Space Treaty to notify a dangerous phenomenon. Thus, this provides us the impetus to carefully study Article 5 of the OST. Article 5 has 3 paragraphs focusing on possible assistance to be rendered to astronauts in the events of accident, distress, or emergency landing. I will not repeat or reading the Article 5, but we should first of all understand that this article was drafted in humanitarian consideration, aiming to afford effective protection to the people involved in the exploration of outer space on behalf of all mankind. This article largely touches upon 3 major issues. It first addresses situations where astronauts are in distress somewhere on the Earth. Second, it addresses equivalent situations in outer space. And third, it touches upon a related obligation to provide information. These 3 issues are the cornerstone of Article 5 and serve as the starting point for our discussion. With regard to the interpretation, I plan to pick up several terms for clarification, which will be of utmost importance for us to understand the application of Article 5. If we look at previous discussions and also journal articles, etc., they mainly focused on the meaning of astronaut. I myself also have research on astronauts in one article regarding, basically on the private participants. If we look at all these publications, they analyze whether space tourists fall within the scope of astronauts. The Outer Space Treaty is the first multilateral treaty to use the term astronauts. While there are different terms used by different countries, for example, China uses taikonaut. No established definition has been afforded for this term. In general, if we really look at the term itself, astronaut normally refers to human beings traveling into outer space for professional reasons of a non-commercial, non-profit nature, non-private nature. Normally, they are trained personnel who understand and are capable of carrying out professional work in outer space directly related to operating the spacecraft. Such a definition can establish a clear-cut distinction with the more recent types of humans traveling to or in outer space, in particular, space tourists or private participants. It is to be noted that the text of the 1968 Rescue Agreement uses the term personnel of a spacecraft. While there's again no definition, it can include commander, pilot, mission specialist, flight engineer, and payload specialist, who are professional crew of each spacecraft. It is generally understood that this concept includes more categories of people than the term astronauts. Accordingly, it is generally agreed that space tourists or probably we say the private participants are excluded from the above 2 concepts. Reference should thus be made to the term space flight participants used in the International Space Station Intergovernmental Agreement, ISSIGA, which refer to people who have traveled aboard space missions but are not part of the crew. Thus, there are 2 types of participants, professional and private participants. Space tourists are not categorized as astronauts, but rather as space flight participants. Space tourists normally receive only simple training, and they could not fulfill the same obligations as astronauts in outer space. In addition, they are involved in space tourism for personal reasons, for their own amusement, and it is not appropriate to consider them as envoys of mankind in outer space, which I will discuss very soon in the next slide. Take into account the above, it would not be appropriate to equate their status with that of astronauts. Thus, space tourists do not have the same rights and obligations as astronauts. Now, we can move to the second term, envoys of mankind. The Outer Space Treaty affords a very high status to astronauts as diplomatic envoys. This status applies to the classical professional astronauts, excluding commercial or private space flight participants. This is fully understandable as astronauts are working fundamentally for public good. At the moment, we would argue that this term is only a figure of speech, no implications as to jurisdictional immunities for astronauts. Now, the third term is all possible assistance, which has been used in the first and second paragraph of the article. In the first paragraph, the term is qualified by reference to astronauts in the event of accident, distress, or emergency landing. The term per se can be seen as a comprehensive obligation to render all sorts of assistance for the sake of international cooperation. However, if we interpret the term broadly, will it put a heavy burden on other countries or other states or not? There is thus a need to strike a balance. Such assistance is necessary to fulfill the underlying humanitarian approach, which means that other states need to assist only in the threatening circumstances so as to avoid overly high burden on other states. Very closely related to the term or the issue which I have just mentioned in the last slide, assistance shall be offered for astronauts in the event of accident, distress, or emergency landing. Now, the term accident, distress, or emergency landing has covered comprehensively situations where astronauts may find themselves not feeling at ease or would like to be assisted. For example, distress seems to be the broadest term of all, including situations when astronauts without suffering an accident, for example, there's no personal injury or damages to a spacecraft, but astronauts might still be in trouble, even if there's no accident. So with this kind of understanding, will it be going too far or too much burden on other states? If we look at the two paragraphs in the Outer Space Treaty, Article 5, the term shall has been used in these two paragraphs. It appears that the obligation to assist is absolute or compulsory. So generally speaking, this article is placed within the Outer Space Treaty. It shall comply with other articles of the Outer Space Treaty regarding for example, which we have just mentioned about the peaceful activities, peaceful use of outer space, international cooperation, and the development of mutual understanding and the strengthening of friendly relationships. Space activities are presumed to be carried out in a peaceful manner with the principle of international cooperation. As such, out of humanitarian consideration, assistance should be given to astronauts in dangerous situations. Now, when we move further to look at obligation, as we know in paragraph 3, there's an obligation for the states to provide information on any phenomena they discover in outer space that could endanger the life or health of astronauts. With the use of the term shall, it is presumed that the obligation is mandatory. However, paragraph 3 of the Outer Space Treaty does not make it clear how to arrive at a conclusion that a phenomenon relevant to this article is discovered. So if we look at some publications, the commentators seem to assume that paragraph 3 applies as follows. The originator of the danger or a third-party observer discovers a phenomenon that may endanger the life or health of astronauts and immediately alerts potential victims and the Secretary General of the United Nations in order to prevent the danger from occurring. However, as we know that different states are at a different stage of their technological development, their capability should be taken into account, since the determination of danger is likely to vary from state to state. As such, this is at the discretion of individual state concerned. They should carry out the obligation in good faith. The standard of reasonable foreseeability should apply, which means that the obligation applies only when the state concerned could reasonably foresee the dangerous aspect of a phenomenon. Otherwise, the state should not be held accountable. Each state should be allowed to make an independent judgment based on the information available to it as to the existence of a danger to the life and the health of astronauts. Even if information available to other states may lead to the conclusion that danger does not exist, each state party should base its judgments only on the information available to it in order to maximize the safety of the astronauts and prevent unnecessary risk to the astronauts. Now, with regard to the timing of a notification, the purpose of the fulfillment of informing obligation is to avoid the danger. If the relevant actors can avoid the danger by their own efforts, they can simply act to avoid the danger. In such cases, they should not be condemned, even if they do not immediately exercise their informing obligations. For example, when actors realize that their activities in space may cause danger, they may first take actions to prevent the danger from occurring. Even if they perform the informing obligations after they have averted the danger, they should not be considered to have violated paragraph 3 of Article 5. But even if the specific danger has been removed, I would also mention that it is reasonable for the states concerned to notify the international community of the situation in order to safeguard the health and safety of astronauts. This is not only conducive to providing lessons for other countries to adopt similar practices, but also conducive to improving the relevant mechanisms, such as data sharing, in order to prevent the recurrence of similar dangers. If the relevant actors could not independently prevent the danger from occurring, as the danger was detected, in order to safeguard the lives and health of astronauts. For example, when a state discovers that a giant meteorite may threaten the space station of another state, it should immediately fulfill its informing obligation, since it can neither destroy the meteorite nor enable the space station to engage in collision avoidance activities. It can only safeguard the astronauts by notifying them of the danger as soon as possible. Now, let's move to the next slide. So with all these discussions, we can see that the application of Article 5 faces some challenges with the latest development of private space flight and space tourism. This is most relevant to the understanding of the term astronauts, as we can see from various publications. Article 5 serves as a cornerstone of humanitarian and other idealistic concerns in the Outer Space Treaty. Thus, we will need to consider possible ways to protect private spacecraft and space tourists. Suggestions have been made as to whether a more detailed protocol or a new convention would be necessary or feasible for the protection of private participants. We, of course, also take note of the ability of different states in discovering dangerous phenomena. With this issue, actually, if we look at discussions, I think for coming up with a new convention appears to be rather difficult. So I think that this shall be further discussed. There are some discussions regarding whether we should consider insurance or the other mechanism for the safety of private participants. Now, consequently, I think we can provide some recommendations for the implementation of Article 5. First, an international information sharing system should be established, as we have just mentioned, situation awareness position. States should establish an information sharing system on space debris, satellite orbits, and so on, which will make it easier for states to determine the existence of dangers earlier and more accurately. And will also help to judge whether or not a state has violated its informing obligation. Second, domestic legislation should be adopted to ensure that non-governmental actors identify and inform or notify inform the dangers in a timely manner. In specific cases, it is non-state actors rather than state parties that are in a position to detect the risk. And in the cases mentioned earlier, private companies involved in space tourism, satellite mega constellations, and space mining may be able to detect the risk earlier. So states should implement legislation to make it clear that non-governmental actors engaged in space activities should notify the state party in a timely manner when a danger is detected. And thirdly, the actor may decide when to notify the danger based on its capability of excluding the danger. When state parties discover the danger, they can avoid it before fulfilling their obligation of conformity. However, if they are unable to avoid the danger alone, they should immediately inform other states and the United Nations Secretary General. So that will be something from the background, the scenario of the Chinese declaration. I think that I can consider. And of course, I think if we look further, the ideal situation, of course, the state parties should notify immediately once noting this kind of danger. But as I just mentioned, the third relevant recommendation basically will have to look into one, try to avoid, try to take actions to prevent. But at the same time, that will be a very ideal that you can also inform. Otherwise, it's rather important to take actions first. So with this, I would like to conclude my presentation and pass to the chair. Michael, please. Thank you very much.
Thank you, Professor. It's very, very interesting, and it's such a pleasure to hear your views on this very important article that I might recall was in the very beginning of the space endeavor that was proposed by the Russian Federation or the Soviet Union way back in the early 60s, which made it into the 1963 declaration as well, and then finds itself enshrined in the Outer Space Treaty. So this humanitarian effort is truly, as you say, the cornerstone of the outer space and of states' endeavors in outer space. And I see that we have a really good question here, and you touched upon a number of these things. We have this question: what are the obligations of states? To states parties to the treaties towards astronauts in the event of accident or distress or emergency landing in the territory or on the high seas. What are the obligations of states to render this assistance? What are your thoughts on that?
Thank you very much. Of course, I think for the accident, distress, or emergency landing, I think on their own territory, of course, they were in accordance with Article 5, and also, of course, we can refer to Article 1 to 4 of the rescue agreement. They will take actions in case they find out or they are informed of these kind of accidents, distress, or emergency landing. They should take actions. That will be something within their own sovereign territory, so they will be able to take the action immediately. But for on the high seas, we do not really find out, I think, actually, if they are in a position to take action. I think out of the humanitarian consideration, we would like to say that they are in a position to take some actions. But I think this we can see the differentiation between different geographical locations of the emergency accidents or or distress. I think that happens. I think it will be useful. I think if we really look at the rescue agreement, I think that will also give us some clear pictures. But anyhow, I think the 3 articles of the Article 5, I think, has already given us some principles, I think, to how to act. Although the terms, as I discussed just now, I think actually did not really go that far. But I think this has been further elaborated later on.
Yes, absolutely, and yes, it was an interesting debate that I was digging into in the travaux of the early days, and I noticed that it was the Soviet Union that had a mandatory duty of this, and that also they also put in the desire for the exclusive right to essentially to refuse any others for providing such assistance, that they would that the launching state would have essentially the first right to retrieve their own equipment, their own personnel on their own terms. And that was an interesting way of looking at the issue, that it really spanned a number of different ideas. Now, I see one other question that I think was on the lips of many of us in the committee and in the legal subcommittee and in the implementation of the treaty, regarding the notification under Article 5 of China. Only just a couple of years ago, this very recent interpretation of this phenomena of the Starlink close flyby to twice over, and it relates to, of course, Article 9. Why do you think that the Chinese government went ahead for a notification or Article 5 and not to engage in consultations under Article 9? What are your thoughts on that and the use of these different treaty articles for these various information and consultation purposes? Thank you so much.
Thank you very much. I think it's good. I think I would say, I think Article 5, of course, I think as the Chinese government have argued, obviously, I think has some relations. But again, I think it's good. I think if you really mention about Article 9, I think regarding consultation, in a way, of course, I think we can carry out. I think if there's some dangers, that's always have the ways to carry out consultation. If you have reasonable doubts, I think, or concern regarding the dangers or risks. But in this situation, we will also mention about the time and when you get the information, get the knowledge. If it's very urgent, then of course the Chinese government has already taken the actions to avoid the potential risks. So that's why when I really mention about the informing obligation, we can decide when to notify, when to inform the international community and the Secretary General of the United Nations. So that's why, of course, idealistically speaking, it's good. I think we can have a consultation, notification, but we will look into the most important to avoid risks. So that's why I think the Chinese government takes the actions to maneuver to avoid the potential collision. And then I think, and then of course I think it continues with the notification. I think if we strictly speaking, there's no clear term about when to carry out or when to notify. So in a way, in the end, it still carry out the obligation of informing. So that's a term. But of course, in the future, I think idealistically, I think notify as soon as possible within what kind of a time frame. I think that will be really good. I think, but anyhow, I think that's the current situation. There will always ways to further improve this practice. I think I was arguing that way, including the consultation.
Absolutely, and it just highlights that there are these different avenues for sharing this kind of information for both, you know, public purposes and also to engage in consultations which appear to be at least at the beginning a private between governments type of approach. And it's a really interesting way to call attention to certain kinds of activities and to look for ways of helping others understand the essentially the situation that is happening on orbit with all of these different different activities that are taking place. With that, I would like to thank you so much for sharing your views and for sharing this little talk on Article 5. It really has been a pleasure, and you've contributed over the years to the United Nations Conference on Space Law and Policy, and I really want to thank you for that as well. And it's a good pleasure to see you again. Maybe if I could just as I noticed, we have our current chair of the legal subcommittee has joined us. Ma'am, would you be willing to stay a bit for the Roscosmos presentation and then share a few words after this? I hope that would be okay.
Thank you, Mike, for introduction, and I would like to present you our views and our approach to the Article 6, international responsibility for national activities. If you don't mind, you could put my presentation on the screen.
Yes, I will do that. Thank you so much. And Madam Chairman, if you would just, we can just wait until Vasily gives his presentation, and then we'll take your brief statement right there afterwards. So thank you so much again, and I'll go ahead and share your presentation now, sir.
Still, while waiting for presentation, I would like to say that it's, in our opinion, it's one of the most important articles in international space law, because the international responsibility means, in our point of view, the responsibility of states. And states, in accordance with the international law, are responsible for activities of all national entities, including private companies and physical or legal bodies that involved in space activities. That means that state is liable at international level for all activities led by private companies, and then during the last 5 or maybe later years, we're hearing about the involvement of private sector in the creation of regulation of space activities. We are not against this approach, but we suppose that such participation of private sector in regulation on international regulation of space activities should be led through the national authorized bodies. They could discuss and could express their concerns and proposals to national authorized bodies in space activities. And those bodies, state bodies, and certainly members of that included in national delegations could express that views, include that views of private companies in the position of the state during the session. Yes, thank you very much. I see my presentation on the screen. So next slide, please.
Yes.
It was just a very beautiful picture, but but I would like to start with the hierarchy of norms governing the space activities in Russia. And next slide, please. So Russian space activities are governed by the Constitution of the Russian Federation, general principles and norms of international law, international treaties concluded by the Russian Federation. And the main law of the Russian Federation that regulates the responsibility at international level for all activities led by private or by state companies described in the law of the Russian Federation on space activities. Due to the provision of that law, the management of space activities are under the jurisdiction of the Russian Federation. That means that our states is fully responsible for all kinds of the activities at international level. Next slide, please. In accordance with the Article 5 of the mentioned law, the general management of space activities is carried out by the President of the Russian Federation. It means that he takes the most important decisions and approve most important plans and actions, considers and approves the main provisions of the state policy in the field of space activities. By presidential decrees could be established the status of particularly important space projects and programs and solve the most important issues of state policy in the field of space activities. We have three kinds of international treaties that could be signed at presidential level, means at state level, at the level of the government of the Russian Federation, and at the level of the authorized in space bodies in space activities of the Russian Federation. Next slide, please. And next slide, please. And in accordance with the mentioned law, the government of the Russian Federation fully involved to implement the state policy approved by the president for the benefits in science, technology, and various branches of the economy, and certainly an international cooperation of the Russian Federation. Government of the Russian Federation submits the proposals on financing the federal space program, provides favorable conditions for space technology development and state support for the industry. That means that our government takes some decisions and plans and funds to support the activity of private sector and to develop private and governmental cooperation in the field of space activities. But at the same time, the government approves legal acts regulating the development, creation, testing, and use of space technology because of the responsibility of states at international level. Next slide, please. And there are two authorized bodies in the Russian Federation responsible for the state activities, space activities. One of them is the State Space Corporation, Roscosmos, I present here, and the Ministry of Defense of the Russian Federation. The difference between the responsibilities of those two entities, governmental entities, is that Roscosmos is responsible for creation, use, and control of space activities for the benefits of different branches of economy, and in conjunction with the authorized body on defense technologies of dual use. Then the Ministry of Defense of the Russian Federation is responsible and organizes the work on creation and space assets for military purposes, and in conjunction with us, is an authorized body for dual use space technologies. Next slide, please. And speaking about the liability, we are speaking about the different legal instruments that implied at international level and facilitate us to control the activities of private sector. One of them is the licensing of space activities. And due to the Article 9 of the law of the Russian Federation on space activities are subject to licensing in accordance with the procedure established by the government of the Russian Federation. And Article 10 said establish the mandatory certification and declaration of conformity of space technology. That means that to justify the conformity of space technology and justify the safety using some kind of space technologies, the safety of space assets, and the safety of the third part from space assets or during the space activities from any accident and from any harmful consequences. We certify the production and the final products made not only by governmental but as well by private companies of the Russian Federation. And obtaining the license and obtaining the certificate on the conformity of space technologies, enterprises obtained quite the permission to use such technologies or to use such assets during the space activities they led. And that means that how is the process? For example, Russian Federation fully support the creation of space debris mitigation guidelines adopted by the COPIOS and the General Assembly. And we consider such recommendations as non-legally binding. But at national level, those recommendations were implemented in different national standards, national procedures and orders and directives that are obligatory for our private companies. And if they are not following such rules or such procedures established by federal laws or by some institutional acts, legal acts, they could be punished in the court, and they could be imposed some fee for not complying those requirements. Next slide, please. And there are some peculiarities of space object control. It's quite repeat the provision of international space law and saying that we are exercising a responsibility during all stages of space activity or a certain space object, from the launch to the end of flight of it. And authorized body for space activities and federal executive body for reference inform corresponding state power entities of the Russian Federation about the launch and landing of space object of the Russian Federation and then needed foreign states concerned. In case of launch, including or end of life of space object of the Russian Federation outside the territory of the Russian Federation, corresponding entities of the Russian Federation execute their function in coordination with the authorized entities of foreign states. I would like to present you an example during the uncontrolled re-entry of our space object Phobos ground many years ago. We informed all countries which territory was laid on possible territory of Earth than the parts of that object could lay down. And we informed them on possible threats, and we provide information how to manage different parts of that object in case they found on the ground of the state or the foreign state. But our experience in this case was quite interesting because some states took decision not only take some measures but inform the population of that country, some countries, about possible accidents, and that provided and disturbing the population of some countries and produced certain concern about the space activities as a whole. That's why we would like to discuss in the future with our partners and maybe during the subcommittee or legal subcommittee or technical subcommittee, or maybe in both, those provision how to inform and how the states should manage the information provided by another launching states on such cases, not to deteriorate the situations, but to be ready for possible harmful consequences. It's very important, and in our point of view, it's fully related with Article 9 of the treaty. Next slide, please. And those parts of Article 24 established some provision and some norms on rescue operation and post-emergency response work caused on the territory of foreign states as a result of space activities. And this provision, first provision, says that we should manage by agreement with authorized body of the state. So that's why Roscosmos signed a lot of agreements on cooperation with different countries in bilateral and multilateral level that includes some provisions on information exchange and notification in case of any emergency rescue operations or emergency situation to facilitate the common actions and mutual assistance to each other. I remember our discussion on those guidelines on long-term sustainability, and I remember this discussion with our American colleagues. It was very interesting with Audrey, and she said that it's quite similar, this international cooperation and mutual assistance. We are not agree with such explanation because those both sentences existed in international space law in the treaty, but in our point of view, it's different meaning. For example, cooperation means that those actions and some kind of activities before any accident, for example, or during an accident. But after the accident or at the beginning of the accident or emergency situation, then we are short of time. We certainly need mutual assistance, not cooperation. I provided an example. If you found a man lying down on a concrete and unconscious, you could not come to him and ask, would you like to cooperate? You're certainly trying to provide assistance. In our point of view, that makes the differences. And parts 1 and 3 of the Article 25 and 27 establish the rules how we should manage our activities with foreign organization and individuals implementing the space activities under jurisdiction of the Russian Federation. And certainly there is a provision that said that they should provide insurance of space assets and related to space activities in accordance with the civil code of the Russian Federation and present law, because no one private or state entity could not be allowed to launch any space objects without obtaining insurance. It's questions of possible liability or in case of accident or in case of some harmful consequences described by Convention on Liability. Next slide, please. And Article 28 of the law of the Russian Federation on space activities describes the legal management of international cooperation. It's easier, I'm just saying that in conflict of norms of the Russian Federation with norms of a foreign state applied to the space activities, the Russian citizens involved in the law of the Russian Federation should be used, if not determined, override, or if not overridden by international law provisions of international treaty. The Russian Federation is a party. That means that then we are part of an international agreement that establish some provisions and some norms and rules different from our national legislation. Certainly, those rules in international law will be applied in that case. That's why we are so serious then we are trying to establish any kind of international regulation mechanism for space activities, because that means for us that in the future we have to apply, to implement those provisions of international treaty, international agreement in our national legislation, and sometimes we need to change or modify or clarify our national provisions, our national rules and norms, and that's why we are so serious and we are so detailed, trying to make those treaties and those provisions of proposed international treaty, even not legal binding recommendations, as I said, that could be implemented at national level in legally binding instruments, very, very serious and very, very comprehensive. Next slide, please. And finally, about the liability. The exact provision was established by Article 30 of the law of the Russian Federation of Space Activities, and established the liability for damage caused by space activities. The provision of this article is quite the same. They are wrote down in Convention on Liability. They just repeated maybe different wording, but with the same meaning and with the same procedures and the same cases which are established by international law. The most interesting part of this article is the second part, and saying that then damage during the activities is caused elsewhere than on the surface of the Earth to a space object of the Russian Federation or property of it bought by another space object of the Russian Federation. It's established the responsibility between two, for example, a space object belonging to different entities, that may be state enterprise, private enterprise, two private enterprises. So we implied that these international regulations even on relations at national level, because those cases and those issues on liability implemented even on cases caused by one object under jurisdiction of the Russian Federation to another object under jurisdiction of the Russian Federation. And the case is solved in accordance with the civil code of the Russian Federation. And the responsibility of companies of under jurisdiction of the Russian Federation, that certainly means the responsibility of the state. Then damage caused outside the territory of the Russian Federation or inside the territory of the Russian Federation shall be covered by the person or organization which has liability insurance for damage to the extent and in the order indicated by the Civil Code of the Russian Federation. That means, and that explains why is obligatory to obtain the insurance to any private company or even to state company. Then we are trying or planning to let space activities or to use a space object. It covers maybe few in the future some responsibility inside at national level, because you know then some company pay its liability damage, then insurance company could take its money back from this person. And in case then Russian Federation covers all kinds of liability and in the full amount. Certainly there are some provisions in national legislations, then the state could go to the court and asking to refund those amounts paid by liability conventions. Next slide, please. So, the Code of the Russian Federation on Administrative Offenses establishes the responsibility of officials of private and state enterprises involved in space activities not to fulfill these obligatory or mandatory provisions of the law of the Russian Federation of Space Activities on licensing this space activities, and without state registration thereof or without a special permit for space activities. There is a special article that are saying exactly, naming exactly that not to obtain license for space activities. And non-fulfillment or undue fulfillment in establishing time of lawful requirement on space Corporation Roscosmos on eliminations of some revealed violations of licensing requirements is a violation of law too, and that as administrative offense, and in that case administrative fine upon officials in the amount of 30,000 to 50,000 rubles, or an administrative suspension on activities for a term from 1 up to 3 years upon legal entities could be implied in the amount of 200,000 to 300,000 rubles. And you could imagine what means for private company suspension the activities for 1 or 3 years. In our view, it means the termination of the business. So it's in our point, it's a very hard but very effective instrument to prevent these offenses and force all entities involved in space activities in the Russian Federation's comply all obligations and those norms of national law on licensing and obtaining this conformity of space assets, not to be their business not to be stopped or limited. Next slide, please. So you could see the provision of the Civil Code of the Russian Federation that describes how the damage caused by the person or property of a citizen as well as damage caused to the property or a legal entity shall be subject to compensation in full by the person who caused the damage. And that means that the insurance, the amount of insurance premium is insufficient to fully refund the damage caused by the legal entity or citizen who has insured its liability. In that case, this person or this entity should cover the difference between the amount of insurance for liability using his own funds, his own money, and shall refund the difference between the premium and the actual cost of damage personally. But in accordance to the Article 181 of the Civil Code of the Russian Federation has the right of recourse to the person who caused the harm. And he says that the person who has paid for damage caused by another person shall have a right of recourse action against the causer in the amount of the compensation paid unless a different amount is established by law. That means that Russian Federation has the same right of recourse to a private company. Certainly to the state company it's quite ridiculous, but to the private company for recourse for compensation then Russian Federation paid in accordance with the Convention on Liability this damage to the foreign state. Next slide, please. But certainly that decision should be taken by court, not voluntary. And I would like to say that it's not a provision on only our mandatory obligation to private company. It's not only our stick to move the camel faster, but this national legislation supported by our governmental and our state budget. And for example, in the budget code of the Russian Federation for this year, and the Ministry of Finance of the Russian Federation, in order to exercise the right of the Russian Federation on recourse action established by paragraph 3.1 of the Article 1081 of the Civil Code of the Russian Federation, shall notify the relevant chief administrator or the federal budget on what the refunding of damage should be paid at the expense of the funds of the Russian Federation in accordance with the corresponding judicial act. That means that in our budgets are previewed some amounts for liability of states at international level to pay for possible damage, for possible harmful interference of the Russian Federations and all entity under the jurisdictions of our states leading during this year and future period. Next slide, please. Now I said that in our budget for this year, the federal budget includes chapter preserving such expenses, and for the range of processes activated the management of risk insurance and liability insurance for spacecraft launch and spacecraft flight test. Certainly, spacecraft under the jurisdiction of the Russian Federation. It includes subsidies for organizations that accomplish property risk insurance when launching spacecraft and testing spacecraft flight. Certainly, we are ready for such cases. Certainly, we would like to avoid such cases, but if any, we are fully responsible for the activities of all entities under our jurisdiction, even private companies. And there, in conclusion, next slide, please. In conclusion, I would like to repeat, then we are talking about the liability insurance the third-party liability insurance for damage caused by during the pre-launch preparation, space rockets, launch spacecraft, constellation operations in the orbit of spacecraft disposal, controlled or uncontrolled re-entry, the most required type of insurance in the Russian Federation, because it's quite obligatory, and if any private company would like to be involved in such important activities which are very important for national security, for the development of different branches of economy, certainly they're interested to be in line with all provisions of the law, including those provision on international liability. And international public fund used to ensure the responsibility of private companies, for example, the aerospace fund is one of such companies. And the annual insurance premium among the all Russian market of space activities now is estimated at $15–20 million. Thank you. Next slide, please. And in conclusion, then we are talking about the participation of private companies in creating international regulation of space activities. I repeat that we are not against the involvement of private sector, but in our point of view, they could not directly intervene during the copious session or during its subcommittee session or during the work of a working group established by such entities. They should provide the concerns and the proposals to the authorized body, members of whose include in national delegations. And after consideration at national level, the presenters of national delegation could express the view and express those proposals after some expertise at national level. And we will be glad to consider all of them. But this mechanism and this procedure previously discussed at national level, in our point of view, quite guarantees that state is ready to be responsible for the activities of the private sector, complying those proposals and those initiatives of private sector. Thank you very much.
Vasily, thank you so much for sharing your views and contributing and telling us so much about the setup for how private sector activities are regulated in the Russian Federation, and of course reiterating the position of the Russian Federation quite aptly that regarding the voices of non-state actors within the committee. We know that this is has been a long-standing position of the Russian Federation. We respect that very, very well. And yes, we often are trying, of course, to find ways that we can bring in views of all actors, of all space actors, so that there can be a way of understanding the full spread of activities that are out there and being planned out there. But of course, the committee and its subcommittees and working groups are essentially the province of states, and we look forward to working very closely with the Russian Federation for years to come, of course, and hearing more and more views of how the Russian Federation handles things and would like to handle things at the state level, for sure. Now, if I may, I would just like to just ask now: is Roscosmos in fact it essentially is an operator of space activities and launching and all of this, as well as a regulator of the activities of the private sector in the Russian Federation? Is that correct?
No, Michael, it's quite different. We are authorized state body to control and regulate the space activities of all state and private sector in the Russian Federation. Roscosmos not launch any space objects. They produced and created and designed by companies, but some companies' capital includes not only private investment, but certainly state investments in this case. And Roscosmos, through the budget, participate as an ordering different space assets for different branches for economy. For example, we could ask our company to produce some satellite in accordance with our international treaty with foreign states for the needs of that foreign states, and we nominate the Russian Federation company to create such satellite, to test and to provide it to our international or our foreign partners. And we control all stages from the negotiations between two or multilateral parties agreement, and we following all stages to control certification process of such spacecraft, testing such spacecraft, conformity with the agreement provisions signed by Roscosmos. So we are responsible not only during the future and possible exploitation of the spacecraft, but we are responsible to complete our obligations of our companies under the foreign partner during the creation and design of a spacecraft.
I see. That's very interesting. Now, do you then, I noticed that you mentioned the implementation of the space debris mitigation guidelines, which is a very big topic of discussion throughout the world. And states have varying approaches to how they implement this. And you mentioned that, of course, at the state level, these are, of course, voluntary guidelines, but then you've implemented these into your national regulations, which then you impose, of course, on your contractors, on your private space industry that is making and constructing satellites and space objects. And so how do you, as Roscosmos, enforce those in the construction of, in the licensing? How do you oversee that those mitigation guidelines at the national level are enforced on companies within your jurisdiction?
Thank you for your question, Mike, because we established a national standard based on those provision of recommendations on space debris mitigation guideline. And some of our national standards are recommendatory for our enterprises, but some of them include technical requirements. And we have a special law on technical regulations that establish special requirements for production, for using special, for example, using special techniques for stage separation on a booster. For example, you know that previously it was used by pyrotechnics to separate a stage of the rocket that could produce small parts of metal particles, and in our point of debris means particles, not garbage. And now we made recommendations, and it was considered and concluded. And now we use different techniques that prevent the appearance of such small particles during the separation of space rocket stages. They're remaining on the first stage, and they're coming down and re-entering the atmosphere and burning in atmosphere. So they are no longer could be considered as a space debris space debris objects. And the next stage, then we are applying those recommendations at national level. It could be applied even in regulations at agency level as a special procedures how company should confirm, or this confirm the conformity of space objects, technical characteristics, and to international technology and best practices as well. Because then we are talking about best practices. We consider those practices, not rejecting, for example, achievements of our American colleagues. We are considering and we are analyzing the techniques used by them, and certainly we recognize that there are a lot of useful and very, very useful from the point of long-term sustainability and mitigation of space debris techniques applied by companies of the United States and other foreign colleagues. And we are trying to imply quite the same techniques based on our own research, and certainly we are in process of negotiations in using possibility to cooperate on the creation of spacecraft, taking in mind those international recommendations.
That's very interesting. That is a thank you for that, for a comprehensive and your response and everything, and sharing this very interesting information. We are all very interested, of course, in the implementation of space debris mitigation guidelines, as well as, of course, the full guidelines for the long-term sustainability of our space activities, which you mentioned as well, how comprehensive that is, and also taking into account the differing state practices, trying to find essentially the best way forward, the way that works for states, the ways that they can ensure that within their jurisdiction that they are taking care of all of those voluntary obligations that they have agreed to. This is, and it's, I would say, very important to recognize that these voluntary measures, these non-binding measures, this latest development in the progressive development of space law, how important it is to demonstrate that this consensus that's reached on developing these kinds of rules is just as important, of course, as the development, of course, in binding regulations and binding treaties that was so important in the past. This is just the latest round of the way that states understand their work and understand their cooperation and achieving the ultimate aim, which is, of course, the safety and sustainability of space activities. Well, with that, I would really like to thank you again, Vasily. Do you have any other final words, or yes?
Yes, Michael, if I may, I would like to comment due to your words explaining that's why we are so serious, not only discussing provisions of possible legally binding international treaty, but discussing as well those non-legally binding recommendations like space debris mitigation guidelines, long-term sustainability guidelines, and those possible norms and rules of responsible behavior. Because in our case, we taking in mind that it could be implemented at national level in legally binding instruments. So we are not Grinch, which stole the Christmas. We're just trying to be serious, and because we would like our partners, foreign partners, should understand our concerns and our approaches, that we are not only producing some proposals or rejections. We are trying to find the way to improve not only international law, but to improve our own legislation at national level. Thank you.
Yes, thank you so much. And yes, I also want to commend your contribution earlier this morning, or earlier today, on this the security aspects with Ambassador Lagos. That's extremely important, and it just goes to show that how much we appreciate having your views on both of these very widely different kinds of topics. I mean, the regulation of private activities and private industry in space activities, the relationship between private industry and the state, as well as the role of the state in working together with other states to ensure safety and security, both very important aspects in space activities. And with that, I'd really like to thank you again for your time and for sharing your views. It's really been a pleasure, Vasily. It's great to see you. Well, we hope to see you again in Vienna very soon. Yes?
Yes, certainly. See you.
Thank you. Thank you very much. Just as before we move to our next presenter, I would like to give the floor to Madame Mayaya, Madame Chair Mayaya, for just to share a couple of words. We had a few technical difficulties yesterday for her opening statement. Won't take a few minutes, but just if you could share a few words as current chair of the legal subcommittee of the Committee on the Peaceful Uses of Outer Space. Madame Mayaya, would you be so kind to share a couple of words with us at this time?
Yes, I'll be keen to share the few remarks today. I'm sorry I could not join. We had some glitches, and I also had some abrupt commitments from the side. I'm really honored to serve the international space community as the chair of the legal subcommittee. And myself, I'm being guided from this lens by the history that has been put together by the legal subcommittee chairs. At the foremost, I would like to acknowledge the new director, Director Artículo, whom I could not share the stage with yesterday. I'll also acknowledge yourself, Michael, and the Secretariat. I know Nicholas is gone, but you guys, you are holding the fort. And you have hosted this conference, excellent conference today, which I'm seeing that there are 185 attendees already. I apologize for yesterday. So I would like to greatly appreciate all the participants for their valuable knowledge and expertise, especially the panelists that have presented yesterday and today. And I am sure that this conference has started very well, and it will continue in a progressive trajectory with all the panelists sharing their valuable expertise. The conference is actually taking place at an opportune time when we are actually being challenged at the global space governance with all our 5 treaties and the guidelines that we have established within the UN corpus. So this conference is coming to us to actually share, collaborate, share information, and share opportunities for partnership, share opportunities for one another to learn from one another, and enable cooperation and in implementation of the space law and the space policy. As I've mentioned, the global space governance challenges amongst those are posed by the great technological advances that we are seeing in the world, especially in the space arena across the world. So it is of great importance that we, from time to time, we come back and we chat about all these issues, sharing more of the issues Vasily has just mentioned on the space debris mitigation guidelines. They were in my notes as well, because they are quite topical, that we look into that. Our space orbit is quite full of, and there are still new actors that still wants to launch their satellites, and with all that, it poses a challenge. We are grappling as the nations, I'm sure, some of us, with implementing the long-term sustainability guidelines, which were approved not long ago, 21 guidelines. And I know that the committee is working on broadening those guidelines to even more guidelines that could not get an opportunity to be looked into at the last time. More other challenging issues that are facing the space law community and the global space governance includes transfer of space assets in orbit from one jurisdiction to the other. As South Africa, I must say, we are looking at those issues as well, practical issues. So it would be very much interesting from us to learn from the big space-faring nations like Russia and the USA that have done all those things. I am aware that there are other upcoming, I'm sure there are still upcoming issues around refueling in outer space, which will also require some legal frameworks. Legal framework on space resources is another critical for space law governance. It's at hand for us. I'm aware that there are conferences that are to be hosted by UNOOSA with Luxembourg and Belgium next year, and in Vienna. It will be of critical importance that we put together all our panelists to discuss such matters, especially this one that I have just referred to, because we are seeing technological advances. They are moving at a faster pace than what we are doing within the legal framework. With those few words, I wish the conference to continue very well. Michael, I'm promising to attend until the last session today, and I will be attending sometime tomorrow as well. And hopefully, I see that the wrap-off will be about 13:50 tomorrow. I will attend all the presentations that will be set up tomorrow, such that we can be able to learn and be able to take this forward to the subcommittee, I'm sure, to the corpus, and to our respective nations that are grappling with all this, with all the challenges. One last comment from me, Michael, would be, this is good that we're having these platforms that are bringing us all together, the technical platforms, but it will also be very crucial for UNOOSA going forward to look at maybe physical conferences, especially for the developing nations like Africa, where I'm coming from. We have the UAC and the Space Secretariat there. I'm sure they need more of this collaboration and intense discussions, such that we are on par, or we learn from each other. Most of the African nations are setting up their space agencies, which means Africa is starting to see space as one of the key assets for taking sustainable development forward. Thank you very much, Michael. Thank you to the participants to listen to me at this stage, and hopefully we're going to continue well. Thank you. I can't hear Michael now.
I'm sorry. Thank you so much for your kind words, Madame Yaya. It is a real pleasure to have you join our conference and share a few words as current chair of the legal subcommittee. And indeed, the Office for Outer Space Affairs is honored for your contribution, your presence. And we, of course, are so happy to support the legal subcommittee over all of these years. And of course, the STSC and the main committee itself as well. We hope to be doing more of capacity building activities, especially the Space Law Conference in the future. We hope to be going back to in-person events, but this one has really shown the broad breadth of interesting and very valuable speakers and presenters we've been able to gather this time, especially under this topic of the Outer Space Treaty for the 21st century, which you have identified many of the core issues that and activities that fall within the treaty, as we've been discussing over these last days, and will continue to discuss. And yes, and of course, our great illustrious Former Secretary Nicholas Hedman will be joining us tomorrow to share some views on planetary protection, his current work in that area as well. So I'll give him your regards, and we'll see you then tomorrow as well. And without further ado, I see we're running, of course, over time as always, but I see that we have our illustrious Professor Sergio Marchisio, another former chair of the legal subcommittee, who is here today to share some words. We're going to skip ahead in our treaty examination to Article 9, and we will go ahead and look at aspects of due regard, which were brought up earlier today by Ambassador Lagos, and which currently and which continue to permeate our discussions throughout all of our work, is examining what regard is due under the circumstances. And with that, I see Professor Marchisio there. I'm happy to go ahead and share your slides. Sir, would you like me to do so? Thank you so much.
So I had to open the connections myself, okay?
Yes, absolutely, sir.
Yeah, okay. And yes, of course, thank you, Michael, for giving me the floor. And if you are ready with my presentation, I will be very happy. And again, thank you very much for support.
Absolutely, sir.
For inviting me to this conferences to Space Affairs Office of the UN.
Just one moment.
Yeah.
Well, I see that my computer has logged me out over here. I will just one moment while I cue your presentation. Oh. Yes, just 1 second. We benefit from all of our technology, but sometimes it's hard to get a handle on it. But I really want to thank you again so much, sir, for sharing your time and thoughts. Just a moment. Yes. And now.
Okay. Thank you. So this is the cover of my presentation, and I would like to.
Let me just try to fix the
Okay.
the way that this is displaying. Mm-hmm. Just one moment. I will have to, I'm sorry, sir. There, do we see now? Just a second. I'm sorry.
No,
It's
no
on.
problem.
Yes.
Thank you for your efforts.
My goodness. It wants to force me into this other view. Okay. Just a second, sir. Well, I'm a bit of a technical loss, sir. What can we see?
If you want to go without the presentation, we can go.
Just let me try. Just don't know why it is. I think we can see it, but I just can't do the full screen, sir.
No problem.
Okay, would you be okay to do this like this? Because the full screen version is not going to work for me. I'm very sorry.
Yes, I have no problem. That's for mostly for the others.
Yeah, of course.
I have no problem. If you
Thank you so much. Please
go
proceed.
this way, no problem at all. Okay.
Okay.
So I was just saying thank you, and thank you all for coming to this conference of the UNOOSA. My presentation, as you see, is about Article 9 of the Outer Space Treaty, and the title was suggested by Michael, so I thank you very much also for this suggestion. Obligation of due regard, notice of circumstances and information needed to ensure compliance by others. So the title, we can go to the second one. Is it possible to? Okay. The title is focusing mainly on the issue of observance of due regard in terms of information sharing to promote international cooperation and coordination among states having corresponding interests in what are likely to be highly contested space activities in the near future. Hopefully not highly, but could be contested in any case. So there is this notion of notice of circumstances and information needed to ensure compliance with the due regard obligation by others. And this reveals the reciprocal character of and nature of the due regard principle. Because notice and information allow space operators to take appropriate steps to protect their interests. It is not easy, of course, to go through the determination of the scope, the contents of due regard, what are the procedural contents of this principle, as well as what are the practical measures to implement it. Since the beginning, the principle of due regard has been considered a pivotal principle, but at the same time, a very indefinite principle. If we look at the next slide, please. If we look at the traditional elements of due regard, we see, for instance, that we cannot draw many insights from the preparatory works. The principle of due regard appeared the first time when the Declaration of Principles was under discussion in the general in the United Nations, together with the freedom of exploration and use. And it was a UK, United Kingdom proposal on the 1963 draft declaration, which for the first time introduced this notion of due regard. Then it was taken again by the Soviet Union draft of the same declaration, and we had a specific principle in the declaration regarding due regard, but no more than the mention of this principle. What is clear from the preparatory works of the declaration, as well as from the preparatory works of the treaty itself, declaration of Article 9, is that due regard was, and this has been considered since the beginning as a condition for the exercise of the freedoms of outer space. And this is an important point because it is a way, it is said very often to limit the freedom of outer space. It's true, but I understand that not only limit the freedoms of outer space, but also protect in a way these freedoms, because taking into account the interests of other states means also taking into consideration the need for consultation and cooperation between states in relation to the exploration and use of outer space and celestial bodies. I remind the classical dictum of Manfred Lachs saying that rights can only be exercised to an extent compatible with due regard for the corresponding rights and interests of other states. And I want to say a few words about this double reference to rights and interests. If we look at the literal language of Article 9 as due regard is spelled out in this norm, we see that the reference of due regard is only for the corresponding interests of outer space, of other states. Due regard deals with interest, not only rights. This is my idea, the idea that I had since the time when I wrote the comment of Article 9 in the Colonial Commentary of Space Law in 2009. The idea that in reality, it seems to me that due regard covers more than the mere or the rights of other countries. It has a broader scope. It regards also the interests of other states. And this creates a problem because due regard in Article 9 requires more than the regard for the protection of interests and rights of states. It regards also interests. Now, we know very well that not any interest is legally protected in outer space law. The application of due regard in space is independent from the existence of a rule that confers a right. Of course, it covers due regard for the rights of other states. This is quite implicit, but this would have had no meaning because it is something with should be done, have due regard for the rights of other states. At the same time, we know that due regard for the corresponding interests of outer space, of other states, covers not only activities that are protected under legally binding rules, but also activities that they are permitted and legitimate by international law. This is the field of the freedoms of outer space. Not all the freedoms of outer space corresponds to specific rights and the reciprocity of the subjective situation, legal situation, obligations. So this is why probably the application, the implementation of the principle seem to be quite difficult because of the character, the broad character of the duty of due regard according to the Outer Space Treaty. And we find this in the scholars that have pondered on the substantive content of the obligation with different results. We know that the principle of due regard has been mentioned in the classical works of international space law, starting from Lux, but I want also to mention the international space law published in English in 2014 by Gennady Zhukov and Yuri Kolozov, and many others. These authors mention the due regard principle, stating that it directly follows from the principle of international cooperation in exploring and using outer space for peaceful purposes. Next slide, please. Yeah, next slide. And this is why, after some years from my commentary to Article 9 in the COCOSLA commentary, I still rely on one of the first interpretations of the due regard principle and of Article 9, indeed, the 1967 article on the evolution of the Outer Space Treaty by Paul Dembling and Daniel Arons. The core of their reasoning on Article 9 laid upon international cooperation in due regard. After mentioning the language of Article 9 on due regard principle in the first phrase, they said that the remaining sentences implement this principle of due regard. So, in their opinion, we can find the implementation criteria for this principle in the same Article 10, which, as it is well known, refers to the avoidance of harmful interference, to the consultation procedures for a way or another settling issues concerning planned activities that can potentially be detrimental to other states. And I think that in a way they are right. The principle is probably not well defined, but at the same time we have the criteria for the implementation of this principle in the same Article 9. Of course, as the situation has changed a lot from the time Article 9 was spelled out and written in the treaty, I think that we have to rethink a little bit all this, because in many instances, as you have said, Michael, this principle is becoming a key point of reference for debate and discussions. We just mentioned the open-ended working group works on responsible behavior in outer space. The ideas about trying to detail what is the principle of the content of the principle of due regard, why not through a protocol to the Outer Space Treaty? I know that all this can be very difficult technically and politically, but it would not be something absolutely impossible, at least, to think about. Another point, which is lacking probably in Article 9, connected with the due regard principle, is the notion of sharing of information, which is contained in the title of this presentation. Should add that all this we are talking about, due regard, criteria, the elements, etc., has to do with information sharing. Notion which is not contained in Article 9, but which should be considered of great importance for the implementation of due regard principle. On the point of how it is possible to balance corresponding interests, and in this I make reference also at the international judicial case law concerning other fields of international law and touching upon the principle of due regard. We all know that it is mentioned 22 times in the Montego Bay Convention, for instance, but the matter of balancing corresponding interests, and not only rights, but interests, the so-called balancing test, of course, is something difficult, requires a mechanism, and in other fields of law, this is carried out mainly by judges on a case-by-case mode. It would be very useful to think about an institutional procedure within the United Nations for implementing this kind of need, the need for evaluating, assessing how to balance corresponding interest in space or lunar activities. Next slide, please. I would also add the Article 5th of the Outer Space Treaty that is becoming relevant, as well as Article 9, and later I will say also Article 11. And apart from the position of the parties, I don't want to judge anything about that, but I remember the case concerning China and USA, the note verbal from China of December 2022, titled Information Furnished in Conformity with Article 5th of the OST, on two avoided collisions, phenomena in the sense of Article 5, with Starlink satellites, which constituted, according to China, dangers to the life or health of astronauts aboard the China space station. USA underlined in the reply that because the activities did not meet the threshold of established emergency collision criteria, emergency notifications were not warranted in either case. But they took the opportunity for reminding all the existing practice in the USA and behavior regarding information sharing to avoid collision in general and risks of collision with manned vehicles, as well as the role of relevant international and legally binding instruments, such as the long-term sustainability guidelines. So the framework to which should be made reference includes not only Article 9 and as we shall see Article 11, but also Article 5 when manned vehicles, space vehicles are involved. Next slide, please. And one field where the due regard has been, of course, mentioned many times mainly in the works of the COPOS and its subcommittees, is the field of space resource activities, mainly lunar space resource activities. Because if we look at the space resource activities, it is quite common understanding that due regard would require consideration during mission planning of how the proposed activities may affect the space activities of other states. Once again, it is something of reciprocal. It is from states that are intend to carry out lunar activities and states that have the intention to do the same. And I understand that the topic has already come up in the context of the working group on legal aspects of space resource activities, and the ongoing exchange of views in the legal subcommittee and in the working group deals inter alia with the identification of dedicated tools and practices for enhanced information sharing within the work of the working group. And this is, in my mind, a key element, as it has been shown by the different proposals that some member states of the legal subcommittee have already put forward for discussion and evaluation. Next slide, please. What I would like to mention here is that, in my mind, apart from the due regard and to implement it correctly, we should take in tandem other two principles, the sharing of information, which means also transparency, and availability of scientific information. Sharing information on the nature, conduct, locations, and results of activities in outer space will certainly help to mitigate risks of accident, foster coordination, and enable cooperation, thereby ensuring the peaceful, safe, and sustainable use of outer space for the benefit of all. The availability of information about space activities would certainly increase the transparency and enhance the safety of space operations. At the same time, we should look at Article 11 of the Outer Space Treaty, which commits states conducting space and lunar activities to inform the Secretary General, as well as the public and the international scientific community on the nature, the conduct, location, results of such activities to the greatest extent feasible and practical. So it is imperative, I think, that Articles 11 and 9 and 11 work together in the future. I understand that it is a task not easy to perform, but if until now Article 11 mechanism has been used only for re-entries of space objects, I think that the UN is the proper location for facilitating efficient and timely sharing of information and coordination among entities responsible for communication and relevant authorities promote the safety and sustainability of outer space activity. At the universal level, we have nothing but the United Nations. We should reinforce the United Nations office for performing such additional tasks as necessary. We can go to the next slide, please, and allow me to say a few words about the Artemis Accords, because my country, I am here as an academic, but I followed the process of the Artemis Accords within my country's authorities. And I would like to remind, this is a limited group of states, because as in the case of the International Space Station, it is originated by a national program of one country. It is not, while open to all countries, the Accords and the program Artemis are, of course, of a limited, for the time being, membership. There are two sections in the Artemis Accord, Section 4 and Section 11, that are interesting for what regards the transparency, the dissemination of information, and space exploration plans. Sharing scientific information is one of the engagements that, on good faith basis, that were taken by the signatories of the Artemis Accord, as well as the principles on the confliction of space activities, which are aimed really at bringing greater understanding to Article 9 of the Outer Space Treaty and concepts such as due regard, harmful interference, through the implementation of these principles in practice. Of course, for non-signatory parties, there are still available all the means provided for by Article 9, due regard, cooperation, consultation, and there should be a way for improving the utilization of this mechanism, which until now has been really utilized very rarely, if not, I would say, never. Back to the next, please. Next slide, please. And then I would like to remind what has been decided in the process of implementation of the Artemis Accords in Baku during the International Astronautical Congress. The head of agencies and national authorities of the signatories meeting, because this was really an initial step towards how to agree on the mechanism for disseminating information about the near-term civil lunar mission plans, and take into account that during this meeting we had already some national lunar exploration milestones, namely the NASA's Artemis 1 test mission to lunar orbit and return in November-December 2022, the announcement of the Artemis 2 crew in April 2023, the Indian Chandrayaan-3 mission to the lunar surface, the JAXA launch of the lunar lander mission SLIM, and in September 2023. So several activities that required an exchange of ideas on how to implement this principle of sharing of information. At Baku, it was also discussed and can say agreed upon an initial set of mission data that once publicly disseminated could support relevant mission planners in the overall process of mitigating and avoiding interference, thereby promoting safe lunar operation. Will the system privileged by the accords and based on notification of the activities and coordination with any relevant actor to avoid harmful interference work properly? My answer is yes, but much will depend on coordination with non-signatories countries. Mitigating and avoiding interference includes at least 3 steps: the steps of information on circumstances, understanding specific missions plans, including those of signatories, of other nations, and industry. The second phase would be the phase of recognition, identifying possible overlaps in mission plans and determining whether interference is possible. And finally, taking steps to mitigate and avoid interference, such as by establishment different mechanisms, altering missions plans or otherwise. All this, of course, is open to the future, and I'm sure that this will be made in good faith by the participants and by the non-participants to the Artemis Accords. More in general, it is my opinion that one could think about the possibility of negotiating some kind of instruments, binding or non-binding, on the meaning, scope, content, and implementation of the due regard principles, taking into account the multiple plans that are being carried out by several states. Thank you very much, and I give the floor back to you, Michael.
Professor, it is such a pleasure to have you share your views on due regard. It's just an exceptional area that covers so many different facets of our work and of space exploration and technological development. You've identified a number of these areas that we've seen also, you know, in the security area. We have seen due regard come about, of course, with relation to, of course, private sector activities as well. But ultimately, you know, the treaty is between states, and this obligation of states to pay due regard is a state obligation. And we see that there is a connection, and this is one of the things that I've been trying to draw out of the panelists and at the conference over these last days, and will continue, is to draw this a connection between these terms, between and you rightly point out this as well, of this connection between Article 9 due regard, this obligation to pay due regard, and having information in order to understand what regard is due under the circumstances. And where that information comes from, we've heard from Professor Zhao and under Article 5, and you also have mentioned this as well, that information can be shared and disseminated by the UN, of course, under that mechanism. Under Article 11, we will hear tomorrow as well from the former and current chair of the working group on the status and application of the 5 United Nations treaties on outer space, the working group that is tasked to examine all of these articles. And this one topic that has come up, this of finding mechanisms of implementing more Article 11. And what is your feeling like and I know that you have covered this, but if you could tell us a bit more about what you feel like, how Article 11 would facilitate this notion of what kinds of information that would be shared would facilitate this obligation to pay due regard. If you could just share a couple more words on that, that would be great. Thank you.
Yes, thank you. As I said, I think that the point on information is sharing of information is really important. And I think that on sharing of information, the first point to be focused on is that a multilateral UN-based system for receiving and disseminating mission span would be preferable. But of course, if this would not be available in short time because of obstacles and other difficulties in putting in place it, I think that this should rely on the single operators, on the single states that would carry out for the time being operations in space or on the moon that can require really a sharing of information in order to avoid harmful interference or other kind of conflicts in in the realization of these programs that could overlap or present some, and also in a positive way, because if you share information, you can also agree on some kind of reuse of, for instance, instruments that are brought to the moon, for instance. If you, this is an important point. I think that, first of all, each state should individually or may individually support the efforts in the UN UNOOSA COPOS, including the possible development of an outer space Article 9 implementation tool and best practices. This is the first step. And as I said earlier, during for what regards the Artemis Accords signatories, in the Baku meeting, there was already the identification of an initial set of mission data parameters, for instance, that are necessary to be known by the public, by the others, by the operators, private and public, etc. And this is a very long list of mission data parameters, which can, of course, be the origin of coordination with others in order to, as I said, avoid any kind of conflicts. The open questions are who will host this information if the UN are not able to do so, or if there is no agreement within the COPOS on how the UN office could perform such a function. I really hope that this will happen, but it would be more difficult to handle relations and coordination among states that are inside the group of the Artemis Accords and the states that are outside this group that have similar plans.
Yes.
The
Yes.
knowledge of what is very important for. And at the same time, I think that each country or operator must identify possible interference relevant to their mission, to their planned mission. And this is really a way for giving implementation to the due regard principle enshrined in Article 9, considering that due regard means also avoid interference, provide information, mitigate potential interference. Maybe I repeated something, but I think, and then for the time being, as we have no universal mechanism on that, of course, it is up to the states to carry out decisions on that in case such kind of situations occur in space or lunar activities.
Yes. Yes, I can tell you that we in the Office for Outer Space Affairs are looking very much forward to some guidance from states on how we may support the implementation of Article 11 in this information sharing function that will facilitate states in respecting their obligation to pay due regard to the corresponding interests of other states. This is something we are very interested in doing. We, of course, maintain the register of objects launched into outer space under the Registration Convention, as well as under 1721B, the resolution, the early resolution mentioned yesterday. I mentioned that as well. And of course, this function and extending this information sharing function that we have a long history with in the Office for Outer Space Affairs to this next phase, essentially, of exploration activities and facilitating this for states is something we really want to do. This is, of course, we are geared up and planning for it. We have a place where we share information under Article 11 on treaty implementation on our website, but we expect that with some more guidance from states from this working group on the status and application of the 5 treaties under the legal subcommittee, we will be able to better support that. And I mean, all of these are, of course, as we've mentioned, they're living instruments in a lot of ways that need implementation in various kinds of manner. I believe you were the chair of the legal subcommittee at the time of the resolution practice resolution, the resolution on registration practice. A number of years
I was a little bit earlier, Chair.
Okay.
There was the first resolution of that kind, the resolution on the application of the concept of launching state. I remember very well that I started my job with the approval of this resolution that was at stake during some time. And I will remember that there was an issue with a comma in the text that in the end was solved. But yes, this was.
Yes, that's it's very much true that our entire consensus can hinge upon a comma. This is absolutely correct, sir. And it's but it just goes to show, you know, this continuity of people that are so interested as yourself and as others that we have, and we're so lucky to have so many speakers who are former chairs and of the legal subcommittee, as well as the current chair as well, and as well as chairs of working groups that work in our committee as well, to show this interest in generating this multilateral consensus on these very crucial issues. And it's, of course, my pleasure to support this entire process from the Secretariat side. It really is a very interesting work, I can tell you, that all hinges on a comma, if you can believe it. Professor, thank you again for sharing this incredibly valuable perspective on due regard, which has permeated our work in numerous different kinds of ways. And it will continue to do so. This is something that is very much a part of our future, as well as, of course, our past. And our understanding of our past, of course, will influence our future. And I really appreciate your contribution on this. We, of course, are up now for a short coffee break. If I may be able to ask everybody to come back in about 15 minutes. So we're talking 10 after 1 o'clock Central European time. In 15 minutes, so that we may begin our next presentation from our professor, who I see is here, Professor Escolar. Go Escolar, thank you for joining as well. And we will go ahead and begin that in 15 minutes on Article 7, continuing our examination of Articles 1 through 12 of the Outer Space Treaty. Thank you again, Professor Marchisio, for your time.
Thank you very much, you.
And we'll see you back, yes, in 15 minutes. Thank you again.
Thank you.